Ready, start. The appellant challenges the impugned award, contending that the learned tribunal has failed to appreciate that the incident had taken place at a spot where there was no zebra crossing for the pedestrian stop, placing reliance on the evidence of respondent number 2 herein, that is, the driver of the offending vehicle, the learned counsel for the appellant submits that the driver had clearly stated that he was driving the vehicle, abiding by all the rules and regulations of traffic, when suddenly the claimant oblique respondent number 1 came near the bus stop. The respondent number 2 further stated that he tried his level best to stop the bus, however, the same hit the respondent number 1 stop. The learned counsel for the appellant submits that, therefore, the learned tribunal should not have attributed contributory negligence on the respondent number 1 stop para. He also draws my attention to the site plan prepared by the police to show that the incident took place when the bus was turning right while coming from the side of Hapur under a flyover stop. He submits that clearly the respondent number 1 should not have been crossing the road at that spot stop para. On the other hand, the learned counsel for the respondent number 1 submits that the manner in which the incident took place was described by the respondent number 1 herein, who appeared as PW1 before the learned tribunal stop. He was not cross-examined by the appellant or respondent number 2 on the same, and, therefore, now the appellant cannot be allowed to challenge the manner in which the incident took place stop para. I am in agreement with the submission made by the learned counsel for the respondent number 1 stop. The respondent number 1 in his statement had clearly stated that the incident had taken place when he was going on foot and was hit by the offending vehicle, being driven in a rash and negligent manner and at a very high speed while it was coming from the Hapur side stop. He was not cross-examined by the appellant or by respondent number 2 on his aspect stop. It was also not put to him that there was no zebra crossing at the spot of the accident stop. This was not even the case of the respondent number 2 in his evidence stop. The appellant is now placing reliance on the site plan to contend that there was no zebra crossing at the spot of the incident stop. However, the site plan also cannot be considered to be evidence of the same stop para. Even otherwise, the offending vehicle was taking a right turn from under the flyover stop. It was supposed to be, therefore, flying at a less speed stop. The very fact that the respondent number 2 herein could not stop the bus in spite of him seeing the respondent number 1 indicates that the offending vehicle was being driven in a rash and negligent manner. Stop. I, therefore, find no merit in the challenge of the appellant on this account. Stop para. The next challenge of the appellant to the impugned award is on the functional disability of the respondent number 1 assessed by the learned tribunal. Stop para. The learned counsel for the appellant submits that the permanent disability suffered by the respondent number 1 was only 60% of lower limb, as he had undergone amputation of right leg below his knee. Stop. It was the case of the respondent number 1 that he was self-employed on the date of the accident, though, no evidence in this regard was led by the respondent number 1 stop. He submits that, therefore, the learned tribunal has erred in taking the functional disability of the respondent number 1 to the whole body also as 60% stop para. On the other hand, the learned counsel for the respondent number 1 submits that the respondent number 1 was, in fact, working as a laborer and was aged around 59 years. Stop. He submits that, therefore, no fault can be found in the learned tribunal taking the functional disability of the respondent number 1 as 60% stop para. I have considered the submissions made by the learned counsel for the parties. Stop. The learned tribunal, while assessing the functional disability suffered by the respondent number 1, has rightly relied upon the judgment of the Supreme Court in Rajkumar versus Ajay Kumar and another, under bracket 2011 1 SCC 343, while has laid down the principles to be followed in such determination as under para. Stop.